The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, aka Good Lawgic. I know I'm late. I know. I'm late. I'm sorry. But I come bearing gifts. It's a way of me expressing that, look, I'm sorry. I shouldn't have been late. I should have been here, like, I don't know, 6 minutes ago, 7 minutes ago. Let's call a spade a spade. I should have been here like 47 minutes ago. Okay, I get it. I'm sorry. I'm late. I come bearing gifts. My gifts come in the form of humor. Yeah, because I can't really reach out to each and every one of you and express my gratitude properly. So the best way I can share a gift with each and every one of you is by sharing this with you. This is an advertisement for last week's presidential debate, which I had not seen. I had not seen this. If I did, I would have had this calendared long in advance. This is Meet the Press's promotion.
The Press Now, coming to you live from beautiful. And welcome to a special edition of Meet the Press Now, coming to you live from beautiful Miami, Florida, as we count down to the third Republican presidential debate hosted by NBC News. I'm Garrett Hake, live from our NBC News Debate Hall spin room, where we are just hours away from 5 Republican candidates taking the stage.
Exciting.
Tonight, it's arguably a game of survival as the field faces major questions about the state of their own campaigns and the state of this race, with frontrunner Donald Trump maintaining his commanding lead and once again skipping the contest. This is Ron DeSantis, an establishment rhino that wears insoles in his boots in order to look taller, and this is Nikki Haley. Nobody really gives a shit about Nikki Haley. This guy is probably just a stagehand. Who the fuck invited this guy?
Wow! I don't know. These are good questions. This guy's probably a stagehand. I don't remember what they say about Nikki. I don't remember. Oh my God. This is the best promotion ever.
In his boots in order to look taller, and this is Nikki Haley. Nobody really gives a shit about Nikki Haley. This guy is probably just a stagehand. Who the fuck invited this guy? And this guy is probably just delivering pizzas. Anyway, nobody cares about these bullshit rhino debates, especially when you know that Donald Trump is going to kick some ass tonight.
Young man, there's no need to feel down. I said, young man, pick yourself up.
There's a copyright strike right there. Oh my God. I don't know who did that. I don't know what mad genius did that. That was very impressive. Very, very impressive. Very, very impressive. So impressive that NBC is genuinely ticked about it. And that makes it even funnier. They're genuinely mad about this. I told you I came bearing gifts. The Hill is reporting NBC News presses Trump campaign to take down fake clip. It's fake news. You're all fake news. Is that his audio by the same guy who's fired from Fox for calling Biden a dictator? Okay, that's possible. Whew. NBC News is demanding former President Trump's campaign. Notice how it's called former President Trump's campaign take down a fake clip circulating on social media that altered a report from one of its correspondents. The clip shared by a top Trump advisor last month shows NBC's Garrett Hake giving a report from the third GOP primary debate, which the network hosted. The first 30 seconds of clip appear unaltered, but then a voiceover replaces Hake's voice calling Florida Governor Ron DeSantis an establishment rhino. They also mentioned that he's wearing insoles to look taller, and saying nobody really gives. I don't think did he say? I thought it was an F. I don't know if this is. I think this story might be fake news. I have to go back and hear it again. I want to make sure that it's accurate.
Look taller, and this is Nikki Haley. Nobody really gives a shit about.
No, he was right. Okay, I apologize. He was right. I was mistaken. It's important to make sure that my reporting is accurate here. NBC News has demanded that Trump campaign take the video down. Semaphore first reported citing two people familiar with the demand. Trump aide who shared the initial clip, Chris Lasavita, followed up hours later. This is who I shared it with. He wrote, to keep NBC News lawyers off my A, please note, this is parody. I know we have to walk you through. So when he sent it out, he goes, this is parody. But that's still not good enough. So there you go. So they're not happy. They're very angry. They're issuing demands. You better take that down. You bad man. You bad orange man. I told you I came bearing gifts. You're welcome. And thank you, Lily. You're too kind. I love having you around. You're awesome. All right. We got that out of the way. I got a few things to cover today. This is one of them. That's not it. Oh, where is it? Oh, no. Oh, where is it? Oh, no. Oh, that's not cool. I wanted to start with the 14-page thing and with Jack Smith's thing. And I actually have two legal documents pulled up here. This is one of them. This is the decision, the 68-page decision, which we are not going through the entire thing, but I am going to go through portions of it that are relevant. And that's the appellate decision on the gag order. Why don't I see Dick Durbin? I don't want Dick Durbin. Not this. Not Hunter Biden. Oh, for the love of God. Oh, I might need to find this now. Here it is. Oh, phew. That was scary. That was scary stuff. Okay, here we go. All right, here we go. Petition for writ of certiorari before judgment. So Jack Smith, special prosecutor Jack Smith, who's looking to throw Donald Trump in jail and throw away the key, has brought a petition to the Supreme Court of the United States seeking to have a legal question adjudicated by the courts. This is an unusual move. I'm just going to start with this. It's a very, very unusual move. That doesn't mean, and apparently the court has acted very quickly in saying we're going to act quickly on this. Like in the same day as the following, they say we're going to act quickly on making a decision as to whether we're going to grant cert on this. So the Supreme Court is willing to move on an expedited basis. That implies to me they likely will grant cert, and this is likely going to end up popping up before the Supreme Court. One of the things that I've said for a while now is that the best chance that Trump has of knocking all these cases out is a decision from the Supreme Court that says that unless a president has been indicted for his activities as president, he cannot, meaning impeached and indicted, he cannot be brought for criminal charges by the federal government or state. That would be the simplest way for them to just flush all of these cases down the toilet. Certainly the criminal cases, the civil issues are a different matter. That might not be as easy. Whether they would be swept away is more of a question. It would probably be more difficult time sweeping those away. But the criminal charges should be swept away. To me personally, I think that's the way it should go. So this is what he starts with this question presented: whether a former president is absolutely immune. Notice how he says absolutely immune. Which, now I just want to point this out. The question presented is not necessarily the question that's going to be asked. It's the way that it's what Jack Smith, the way he's wording this question, and this is true of life in general. Frequently, the answer you get will depend on the question that you ask. The nature of the question will determine what the answer is. So a lot of times when you're coming up, and especially when you're coming on appeal, this is not an appeal. This is a petition for judicial ruling. But the nature of how you phrase the question will frequently dictate the answer. So Jack Smith, he's been practicing law for long enough and swung and missed enough times to know that you got to frame your question properly. So how does he phrase this question? Whether a former president is absolutely immune from federal prosecution for crimes committed while in office, or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. Now, this is not really English. This is very weird. He's working so hard to try and structure the question in a way that he thinks lends itself towards the answer that he's seeking, which is that yes, he can be prosecuted, and he's not absolutely immune. So there's a few qualifiers they put in here which make this question very inartfully. It doesn't sound like English if you actually think about what he's saying. Yes, I understand a layperson would understand it, but if you're actually trying to break down what the question is, first of all, notice how he says absolutely immune, meaning there's absolutely no way, no matter what happens, that he can be prosecuted. Knowing full well that most judges are loath to ever decide that anything is absolute. We can't. There's some situations we might be able to picture where something could happen that a judge, he wouldn't have to be impeached first. Imagine 50 years from now, President of the United States goes into Congress, okay, on the day before he's supposed to leave office with a machine gun and destroys and kills every person in Congress. So obviously he's not going to be impeached. But that's so to say absolutely immune. I mean, it would imply that, and even in that case, when there's no Congress left because he killed them all, which I think few people would say, oh yeah, in that circumstance he would be immune from prosecution. So that's part of the reason he uses this language of absolutely immune from federal prosecution for crimes committed while in office, or is constitutionally protected from federal prosecution when he has been impeached but not convicted. See, before the criminal proceedings begin, this is very weird. Why would you say before the criminal proceedings begin? This is such a stupid. This is like how a child writes this. This is not a good reflection on Jack Smith. Why would you say before the criminal proceedings begin? It's the same question even if you take out those last 5 words. You're asking whether it could be whether he's immune from federal prosecution if he's been impeached but not convicted. But like a child, like a high school student who's like, a C student, he finishes it off with these 5 words here, which makes the entire thing much more awkward. It's just poorly written, which is a good sign for Trump that Jack Smith is kind of incompetent. But the other thing I'll point out about this is what he says here is that he's been impeached but not convicted. This is not necessarily true. This is not necessarily true. Because it's a question. as to whether or not he's been properly impeached. The proceedings by which Congress went forward and the House went forward and engaged in this impeachment setting were very strange. It was a very unusual type of thing from what I recall. I'm not sure about the timing of it, if it was before January 20th or after January 20th. I think the Senate hearings were after January 20th. But I'm not sure about whether the House impeachment. In fact, let me look that up. Some have this properly. So I have this proper. When was what date? Let me get this date. What date was Trump impeached? Second impeachment. It was January 13th. Okay, so it was before it expired, was the impeachment. Okay, so, but the proceedings by which they engaged in the entire thing, they didn't appoint a committee first before they did it because they were so urged to do it, which arguably they had to do. The timing on everything on it was the way they conducted the proceeding was very bizarre, and I don't know. I'm not even sure why the impeachment absent conviction would even be relevant. It's a very strange thing. It's a very strange thing. In other words, just because the House impeaches someone, how does that make it more convictable offense? The nature of the question implies that it's that because he's impeached by the House, this somehow translates into the federal prosecutor's office having more authority to go after him. As if there was no impeachment, well, then obviously he wouldn't get it. But obviously we couldn't prosecute him. But because he's been impeached, that now means that the U.S. District Attorney's Office has some license to prosecute for federal crimes. I don't understand why that would be, when everyone understands that the impeachment is pretty much like an indictment and is considered innocent until proven guilty. And ultimately, to the extent that the Senate is the one that convicts them, like is the jury in this sense. So in that case, why would the impeachment be relevant at all? So I think that it's a poor choice on Jack Smith's part to fixate on the impeachment. But I guess he figures that since there was some sort of quasi-impeachment, a procedurally deficient impeachment, that somehow gives greater gravitas to his justification for going after him. That's the question he presented. And I will certainly, when the reply comes, assuming cert is granted and opposition will certainly come from Trump's team, I will most definitely go through their papers. All right. So this is not, even though it says it's 81 pages, it's much shorter than that. I think the whole thing is only like 14 pages. So it's not a lot here, but this is pretty important stuff, and this could theoretically knock out all of these criminal charges, which is why I think that this merits our attention. Scrolling. All right. Special counsel on behalf of the United States respectfully petitions for writ of certiorari before judgment to the United States Court of Appeals for the District of Columbia Circuit. The opinion order of the district court is not yet reported, but is available. The judgment of the district court was entered on December 1st, 2023. The respondent filed a notice of appeal on December 7th. So we shouldn't be at the appellate level yet. We shouldn't be at the Supreme Court level yet. But he's jumping past that and saying, let's go to the Supreme Court because I don't want things left in hiatus for a while. Because whatever decision comes out from the appellate court is ultimately going to be appealed to the Supreme Court. Good chance the Supreme Court's going to have an interest in this case. So let's move forward and actually bypass the circuit court and go straight to the Supreme Court. The jurisdiction of this court is invoked under 28 U.S.C. 1254, subsection 1 and 2101E. See example, Biden v. Nebraska. This case presents a fundamental question at the heart of our democracy. whether a former president is absolutely immune from federal prosecution for crimes committed while in office or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. I don't even know I don't even know what this means before the criminal proceedings begin. It means that he was impeached before the criminal proceedings began. Does this mean if he's immune before the criminal proceedings began? I don't even understand what he means or why these 5 words are here. It's ponderous. It's such poor English that it makes me think that I'm like, what school did Jack Smith get into? My God, this is awful English. The district court rejected the respondents' claims, correctly recognizing that former presidents are not above the law and are accountable for their violations of federal criminal law while in office. This is their opinion as to what the district court concluded. I mean, so it is what the district court concludes, their opinion in saying that it was correct. He's looking to have the district court upheld. By the way, Grifty, member for 3 months, says, I have a theory. He's skipping D.C. Circuit because they were going to agree with Trump by sending SCOTUS they become the bad guys instead of the liberal D.C. Circuit. It's possible. It's possible. It's not clear how he would know how they would fine. It's really, I mean, that would probably be a struggle for him. I think that this is more of a timing thing. I think he wants to get this thing. I think he wants to do everything he can to pave the road for these convictions that he's hoping to get to basically be cleared through in short order. So if he can cut out a step in the process, in that case, he thinks that he's expediting everything here. And perhaps that's why he's seeking petition. So I think he's looking to streamline because, and we'll see in these papers, he actually brings up the timing as being very, 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 very important. It's very important. I don't know why it's so important, but apparently he thinks it's very important. Respondents' appeal of the ruling rejecting his immunity and related claims, however, suspends the trial of the charges against him, scheduled to begin on March 4th, 2024. So I don't want to have this thing suspended. We're supposed to go to court in less than 3 months, and I don't want there to be a suspension of our trial. It is of imperative public importance that respondents' claims of immunity be resolved by this court and the respondent's court trial proceed as promptly as possible if his claim of immunity is rejected. Why? Why is that so imperative? Why do we have to have a decision now? Why is that imperative? You sat back on this thing for 3.5 years, and all of a sudden now it's so imperative that we get this thing decided right now. Respondents' claims are profoundly mistaken, as the district court held, but only this court can definitively resolve them. I agree with him on this sentence. I think only the Supreme Court can definitively resolve this. There's no way anyone else can possibly resolve this other than the Supreme Court. So if the Supreme Court punts on this one, I'm just done with them. They have to answer this question. This is something that all America wants them to answer. And if they punt on this question, my God, what if utter failing. Utter failing. The court should grant a writ of certiorari before judgment to ensure that it can provide the expeditious resolution that this case warrants, just as it did in the United States v. Nixon 418 U.S. 683. Respondents served as the President of the United States from January 2017 until January 2021. The indictment alleges that respondent engaged in a systematic and deliberate efforts to overturn the results of the 2020 presidential election and prevent the lawful transfer of power to his successor. On August 1, 2023, a federal grand jury sitting in the District of Columbia charged respondent in a 4-count indictment. Ooh, a federal grand jury. Ooh. Count 1, which charged conspiracy to defraud the United States in violation of 18 U.S.C. 371, alleged that respondent, then a candidate seeking re-election to the presidency, conspired with, among others, several individuals outside of the executive branch to overturn the legitimate results of the 2020 election by using knowingly false claims election fraud to obstruct the federal government function by which those results are collected, counted, and certified, which, by the way, I don't even understand 90% of what they raise in there. I'm not sure how it is that that's obstructing the federal government's function. But the indictment further alleges that respondent aimed at accomplishing the conspiracy's objective in 5 ways. 1, using deceit toward the state officials to subvert the legitimate election results of the states. And using deceit to organize fraudulent slates of electors in 7 targeted states. I don't understand how that's that's not really using deceit. It's not using deceit. They weren't tricking anyone. It wasn't to send false certificates to Congress. Not really clear who was deceived there, Jackie. Leveraging the DOJ to use the seat to have state officials replace the legitimate electoral slate with electors who would cast their votes for respondent. Leveraging the DOJ? What? How does he leverage the DOJ? Attempting to enlist the vice president to fraudulently alter the election results. Oh, okay. So that's actually something that was probably in his power, given the fact that Congress changed the rules as to what the vice president can do. So I'm not sure how that is really an issue. During a certificate proceeding on January 6th, and directing supports the Capitol to obstruct the proceeding, which apparently he doesn't think that they have a First Amendment right to protest the government. So telling them to exercise their First Amendment rights, obviously very, very wrongful stuff here. A lot of wrongful stuff. Oh, is there a sixth thing? Hold on. We're gonna count this off together. He said conspiracy objectives in 5 ways. 5 ways. 1, I was counting them off here with you. Deceit towards state officials. 2, deceit to organize fraudulent slates of electors. 3, leveraging the DOJ. 4, attempting to enlist the vice president to fraudulently alter the election results. 5, directing supporters to the Capitol to obstruct the proceedings. And exploiting the violence and chaos that transpired at the United States Capitol. Okay. Very professionally done here, Jack. Very professionally done. Counts 2 and 3, which incorporate allegations from count 1, charge conspiracy and substantive violations of 18 U.S.C. 1512, corruptly obstructing the certification process, and all this other repetitive crap in count 4, which is alleging the same count 1, but those include that the respondent conspired to violate one or more persons' constitutional right to vote, which is kind of funny. And district court scheduled the trial to begin on March 4, 2024. Jurors set to complete questionnaires on February 9, 2024. So we're supposed to begin the whole jury selection process is like 6 weeks away. Exciting stuff. And so was the district court's recognition of the public's right to a prompt and efficient resolution of this matter, which is bizarre. Because why does the public need to know this? I mean, clearly the objective that they're saying here is the public has a right to know this before the election. Which, by the way, my God, if he was to get convicted before the election, I think he'll win 40 states. I think he'll win 40 states if he gets convicted before the election. They're so stupid. He's so short-sighted. He thinks that that's going to like kibosh the campaign. You think it's going to kibosh a campaign? All right. You also think that you have 5 elements and you're listing off 6. I don't think you really have your head on straight. Respondent moved to dismiss the indictment on the grounds inter alia that he enjoys absolute immunity. Inter alia is a Latin term that attorneys use in legal documents, which basically means amongst other things. So whenever you have a Latin term, we always put them in italics. That's a standard writing thing that we do, writing technique that attorneys do. So respondent moved to dismiss the indictment on the grounds, amongst other things, that he enjoys absolute immunity from criminal prosecution for acts taken within the outer perimeter of his official responsibilities, and the indictment allegations all fall within that scope. He also argued double jeopardy principles in the impeachment judgment clause. I don't like the double jeopardy principles. I don't like that. Because I do think that the reason I don't like the double jeopardy claim is because I think that vitiates the first argument, What I mean by when I say vitiate, what I'm saying is it actually cuts back against the first argument. So you make your nice, strong first argument, and then you make your second argument, which basically says, hey, everything I said in that first argument, I don't like it. Here's my lightsaber. I'm going to start hacking to pieces my own first argument with my second argument. You can argue in the contrary. Yes, and you can do that before the court. But it doesn't sell well. You're technically allowed to do it. It just doesn't sell. So while there's nothing legally improper about it, arguing in the alternative, it just doesn't sell because it sort of makes your whole smell test bad. So what do I mean by that? Well, the double jeopardy claim is basically, well, you already tried punishing him once by impeaching him. Now you want to try and punish him a second time by having him thrown in prison. Well, what was your first argument? Your first argument is that he has absolute immunity. What does that mean, absolute immunity? Are his lawyers planning on getting up before any court and saying that in all circumstances, no matter what a president does, he has absolute immunity? There's two ways you can present this argument. One is this whole outer perimeter argument. A second way is, yeah, you know what? That's just the way it goes. Unless he's impeached, yeah, that's the way it goes. Now, the outer perimeter argument is a rough way to go. And the reason to sticking exclusively to an outer perimeter, what does that mean, outer perimeter? It means anything that's in the general ambit, the general umbrella of what the president's supposed to be doing, his functions in general. So even if there's nothing specifically saying a president is charged with a duty of having in elections with integrity and getting proper outcomes of elections, it's in the general orbit of what we expect a president to be overseeing. If you look in the Constitution, there's really nothing in the Constitution that says that that's his job. But you can see how that it does sort of fit within, the executive branch, making sure things are being run properly in our country. So you can see how that would fit in the general orbit of things. And if he's doing something in that general orbit of things, even if it's not specifically to make sure that there's, this element or that, but if it's anything that he does that's in that orbit, even if it's having a new slate of electors, that's all part of the same overall orbit. So now he can never be prosecuted. Never, ever be prosecuted. That's one way to make the immunity argument. That's one way to make the immunity argument. But there's a second way to make a presidential immunity argument, which is it's not about whether he's doing things that are part of his whole thing. The point is that anything he's doing, it's because he's the chief executive officer. He's the commander-in-chief. He is the head of the entire executive branch. That the only way for him to be ever criminally prosecuted is if first there's an impeachment followed by an indictment in the Senate. And that way, you're sort of saying that's how the process just works. That's how the Constitution sets things up. You can't charge the man whose job is to ensure that all of our laws are properly upheld with breaking the law, because he has such carte blanche in how he conducts himself. So that being the case, the only way that you can ever bring him for charges is if he's first impeached and convicted. To me, this is a very strong argument. Because this way you don't have to start proving that everything he was doing was within the ambit of the outer perimeter of official responsibilities. Because let's face it, if he relies on this whole outer perimeter of official responsibilities, he's going to have to go through this whole legal process to establish that all these steps he was doing, every step he's doing in the chain was part of that outer perimeter. So now you start looking at this action, that action, this action, that action. They got 147 pages of claims against him. Each of them have 57 allegations on each page, and they're going to find a handful of them that you can say, that's a tough one to fit into the outer perimeter. So what are we going to do? We're going to end up saying that those he can be charged with? As opposed to one fell swoop argument. And it's a very simple argument, which is consistent with the Constitution, which you have 6 justices in there who kind of like the Constitution. You have 3 who don't really like it very much at all, but you have 6 who kind of like it. And even if they don't like Trump, certainly 3 of them seem to kind of dislike Trump. Even if they don't like him, you can understand how they don't really like the idea of a president being criminally charged, because if this happens to Trump and the Supreme Court allows this to go forward, you can anticipate it's going to happen to Biden. You can anticipate it's going to happen to anyone over and over and over and over again. And that's not a way for a healthy republic to be operating. Accordingly, you can expect that the Supreme Court is going to be very motivated. Those 3 in the middle who decide all of these decisions are going to be very, very motivated to come back with a decision that basically says, look, there's got to be really limited circumstances where you can criminally charge a president. Really, really limited. And you know how you do that? You say, if you establish one bright line rule, boom, this is the bright line rule. No criminal charges unless impeached and convicted. Boom, there you go. Impeached and convicted, have at him. The guy must be really terrible if his own party is willing to convict him in the Senate. It's a very easy thing. It's an easy sell to the Supreme Court. So I don't like the fact that it doesn't seem as if Trump's counsel is really pushing forward that direction for arguing presidential immunity. Instead, they seem to be focusing more on the outer perimeter and anything he's doing in that scope. You can push forward both of these claims. But I really like I really like the whole argument about conviction post-impeachment, a convicted impeachment. I like that claim a lot more because it is just an atom bomb. It basically says, go the hell away. You're done. There's nothing to discuss here. Unless the Senate impeached and convicted, there's nothing to discuss. It's so simple. And the court would love to have a simple rule like that. And that's why they should really be selling that to me. In my opinion, I think that's strategically the soundest approach to have. Are they going to raise it? I expect they will. I expect that they will. And we haven't seen their opposition to this petition. I expect that they will. To me, that is, you basically want to hand the Supreme Court an atom bomb to end all these stupid criminal charges from being raised every 4 years of whoever left office last. It's the perfect atom bomb to hand them. Easy sell to all 6 people who are going to be listening to you. The other 3 will be off snoozing and basically, writing their dissent before you come in there for oral arguments. But it's that Ketanji Brown Jackson and Sotomayor and Kagan, they're going to be sitting there basically playing rock paper scissors on who's writing the dissent before you actually start an oral argument. But that's how you hand yourself an easy win. And I just hope they do it. I hope they go down that road. Okay. Where was I? Okay, so Jack Smith is very fixated, however, on these arguments. So now, once you argue this whole outer perimeter, if you do make that second argument, that there has to be an impeachment and conviction, if that is an argument you make, how do you come back now and say, oh, well, once someone's impeached and convicted, you can't criminally prosecute them? You can't criminally prosecute them because that's double jeopardy. Well, then how could you ever criminally prosecute him? Let's assume that the guy is a lunatic. Let's assume that the president himself, he and his right-hand henchman, like some, who's like basically like Otis to Lex Luthor, they decide, you know what, there's too many people, too many Americans, we're going to poison half the country. And they're going to go late at night into like the reservoir and just start dumping in like arsenic. So, so now they get impeached and convicted. You're going to say, oh, double jeopardy, they can't be held criminally liable. That sounds retarded. Who would say such a thing? That's the most retarded thing in the world. So, yeah. So that's why I don't like this double. That for all those reasons, I don't like the double jeopardy concept. The government responded that a former president has no such absolute immunity from federal federal criminal prosecution, that even such immunity existed, it would be narrower than the outer perimeter standard that defines the president's immunity from civil liability. that even if the standard applied, indictment should not be dismissed because it alleges conduct falling outside the outer perimeter of the president's official responsibilities. You see, this is what I told you. And they will. They'll certainly argue that there's all, and then you have to start getting into the whole nitty gritty of what's your claim? What's this? What's that? The whole outer perimeter thing. Oh God, what a nightmare! If the Supreme Court comes out like, yeah, it has to be within the outer perimeter, what a nightmare that's going to start presenting. It's like, wait, is this within the outer perimeter? Is it not? We're going to start having a whole body of case law as to what's within the perimeters and ambit of what the president's supposed to be doing or not doing. It's so sloppy. It's so messy. It's such a pain in the neck. And who the hell needs it? We'll still end up having one case after another, trying to decide what's within the perimeter or outer perimeter of what the president's supposed to do. It's so stupid. It's so dumb. The response double jeopardy argument lacks merit. Like I said, I don't love the double jeopardy argument. The district court denied respondent's presidential immunity claim and his related double jeopardy claim. The court concluded that the Constitution's text, structure, and history support the conclusion that respondent may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office. Although the Constitution's text does not address presidential immunity, the court observed that silence did not reflect an understanding that a former president possesses immunity from federal criminal prosecution for acts taken while in office. Here's the thing that's also kind of stupid. I don't want to get into. I mean, I was going to start talking to his pardon power and how he could pardon himself. And what if he commits a crime and then pardons himself 10 minutes after he commits the crime? But that's just going to convolute things a lot more. And Lord knows it's convoluted enough already. It's convoluted enough. Yo, Mr. Luthor. Mr. Luthor, Otisburg. Christopher Reeves was the best Superman ever. The only Lex Luthor is Gene Hackman, okay? That's it. I don't want to hear any arguments to the contrary. Why is this thing so loose? I need it tighter. I have like a screwdriver here. This is just too spinny. That's better. Okay. But I digress. To the contrary, the court explained that one constitutional provision that respondent invoked, the Impeachment Judgment Clause, U.S. Constitution Article 1, subsection 3, cut against his immunity argument. The Impeachment Judgment Clause provides, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Yeah, so you see, and that's what implies that there has to first be this impeachment and conviction. The court noted that the clause's first part limits the penalties of impeachment to removal and disqualification from office. And the second part clarifies that the party convicted, party convicted by the Senate of impeachment shall be liable and subject to indictment, trial, judgment, and punishment. What if he's not convicted? Then he ain't. It's the easiest argument. God. May face later criminal prosecution, but that any further punishment may not come from the legislature. It's like, do they not see the word convicted? Did Judge Chutkin not see the word convicted? The party convicted. So stupid. The district court reasoned that several features of the impeachment judgment clause undercut respondents' assertion that it confers any immunity from criminal prosecution. First, the term nevertheless clarified the clause's first part addresses the penalties the legislature could impose following impeachment. does not bear when the party would also be subject to criminal prosecution, meaning it undercuts the double jeopardy. You can be impeached and then later. That makes sense. Second, materials written contemporaneously with the Constitution, such as those from Alexander Hamilton and James Wilson, do not reflect the view, let alone a widespread consensus, as respondent contend that the impeachment judgment clause renders former presidents immune unless they were impeached and convicted. Okay. They just happened to choose the word convicted. They wrote the word convicted. They just didn't really mean it. Yeah, okay, it says convicted. It doesn't. That's one of those words that's like, it's a very fleshy word, convicted. It could be interpreted so many different ways. It doesn't really mean convicted. It means like they talked about conviction, and there was discussions of conviction, and that's kind of the same thing as actually being convicted. He might lose 9-0 again. He really might lose 9-0 yet again. Wouldn't that be delicious? Third, respondent's interpretation of the impeachment judgment clause relied on a negative implication that a president who is not convicted in an impeachment prosecution cannot face criminal prosecution that reflected neither logic nor common sense. Okay. No common sense there at all. Finally, respondent's interpretation would produce the untenable anomaly that a former president would be immune if he committed a crime that was not treason, bribery, or other high crimes or misdemeanors. Yeah, you know what? High crimes. How is that untenable? That, you know what? Maybe he shouldn't be convicted of some stupid paper issue, which is not a high crime. Idiot. God, he's so dumb. I can't wait for SCOTUS to just kick these cases out on their butt. If they don't, I'll tell you this much. I'll be flabbergasted if SCOTUS does not toss Jack Smith. Bring him in, ring him out, and toss him. For which impeachment is not available, so would be immune if he committed a crime that was not treason, bribery, or other high crimes, misdemeanor, for which impeachment is not available, committed the crime near the end of his presidency, or covered up the crime during the time of his presidency. Yeah, them's the breaks. Turning the text to structure, the district court reasoned that the public interest in a former president's criminal prosecution outweighs the theoretical asserted burdens such as prosecution entails. Say that one more time. Let's. I need to process this sentence. Let me read this one more time. Turning from text to structure, the district court reasoned that the public interest in a former president's criminal prosecution outweighs. So, since the public has such an interest in his prosecution, that outweighs the theoretically asserted burden such a prosecution. And so, because the public really wants it, we can take the Constitution and throw it in the garbage. Because that's what the public really wants. Since they have such a public interest in the criminal prosecution, they all want to see him get punished. So that's why whatever it says in the Constitution really shouldn't matter that much. Why is everyone making such a big deal about what it says in the Constitution? All these people here really want it. Concerns about chilling presidential conduct were minimal. Obviously, there's no way this would have any impact on any president in the future, the court noted, because whether to intentionally commit a federal crime should not be among the difficult decisions a president faces. No, it's whether it's going to be twisted and interpreted as a crime. Idiots. This is and I'm referring to Judge Chutkin on this one. In addition, the court stated the possibility of vexatious. This shows you how twisted the judge was, how ridiculously twisted that she is. Because I'm sorry, that to say that there's only minimal concern about chilling presidential conduct and pretend that that committing a federal crime is not among the difficult decisions the president faces. Nobody thought what he was doing was a federal crime. That's the whole point. 0 people thought that. In addition, the court stated the possibility of vexatious post-presidency litigation was much reduced in the criminal context, given robust procedural safeguards attendant to federal criminal prosecutions. What are these robust procedural safeguards? What are they? What the hell are these robust procedural safeguards? All you need is a motivated prosecutor. Plus, according to you, that prosecutor can come from either side of the aisle and can even come from state court or anywhere in the country, like Fannie Willis in Atlanta, trying to charge him for things he did in Michigan. This is so stupid. But that's our robust procedural safeguards. It's very limited. It's limited to the 17,000 federal prosecutors. They're the only ones who can actually do it. Those are robust procedural safeguards. I think Judge Chutkan lost her mind. I do. I think she lost her mind when she wrote this decision. By contrast, the public interest in fair and accurate judicial proceedings is at its height in a criminal setting. Oh, yes, fair and accurate. It's not, in no way is it political. Holding a former president criminally accountable, the district court observed, is essential to fulfilling our constitutional promise of equal justice under the law and furthers the public interest in an ongoing criminal prosecution. The public interest, apparently, that's the public interest. Whatever the public wants means we can toss the Constitution and just throw it in the scrapper. Just you get your big. We need like the oversized garbage disposal, so we can get the entire Constitution in one fell swoop and just jam it in there, and then just have that loud. The public demands it. If the public demands it, what are we going to do? We're servants of the people. Whew. All right, I'm going to pause. Catch my breath. All right, pause over. The district court also found nothing in history to justify the absolute immunity that respondents sought. The court discerned no evidence that the founders understood the Constitution to bestow such immunity, and the executive branch had expressly and repeatedly concluded the former president was subject to criminal prosecution. President Ford's pardon of former President Nixon aimed to prevent the latter's potential criminal prosecution. Just because Ford thought that he might be subject to it doesn't mean that he was, or that the act wasn't purely ministerial. It was a way of trying to put it to bed. But all of a sudden, this tells us what our founders thought. You know who explained the Constitution to us and made it so clear? You know who made it so clear to us, what the Constitution is all about? President Gerald Ford. The wisdom of President Gerald Ford. Insightful President Gerald Ford. The brilliance of President Gerald Ford. Many of you are far too young to understand how comical that is when he's considered to literally be the stupidest president ever. Like he was like incredibly stupid. They continually mocked him for being an idiot. Disgusting to think that you could just ignore the Constitution. It should only happen when some megalomaniac tries to overturn a presidential election. I know who you are. I know what you're up to. I understand what this is all about here. Okay? I know who you are. What's that awful smell? I know who the hell you are. Okay, and I know when I'm being trolled. So no, I'm not taking your bait. I'm not taking your bait. This is a friend of mine. This is a friend of mine who's trying to troll me into screaming at him. I'm not falling for it. I'm not falling for it. All right. Joe is boomer years old. That is how old I am. I don't remember Ford's presidency. I don't remember his presidency. Okay. I'm too young to remember his presidency. I simply recall him as the president who was known as being like President Dumb. Like really, like I was actually just Googling while I was talking to you all here. I was busy Googling President Gerald Ford dumb gaffes, but I couldn't find anything quick because I wanted to. So I figured I could probably get like a whole litany of him like falling on his face or saying like things completely like they made Yogi Berra look like sage wisdom. Although Yogi Berra actually was, that's a poor example because he really was sage wisdom, making AOC look like a genius. The district court found nothing in history to justify the absolute immunity. The court discerned no evidence. Founders understood the Constitution to bestow such immunity. And we got Ford's pardon of Nixon, aimed to prevent their criminal prosecution, demonstrating the respondents' view of presidential immunity from criminal liability stands at odds with his predecessors in the Oval Office. Well, if Ford didn't think it, then clearly no legal scholars would ever disagree with Ford. In addition, the district court noted that Fitzgerald had analogized a former president's immunity from civil liability to the similar protections provided to judges and prosecutors. Fitzgerald? What? Fitzgerald? Is that a case they referenced earlier? Oh, it is Nixon v. Fitzgerald. When you have Nixon v. Fitzgerald, you reference it as Fitzgerald? Really? Really? Okay. I don't know who does that. Rather than going by the first name of the case, like Nixon, you put in italics so we know it's a case, not the individual. But the court explained and that's president's immunity from civil liability. What the hell does that do with criminal liability? How is that relevant? How is Nixon v. Fitzgerald, which is dealing with a civil case, how is that relevant to what criminal liability he would face when the Constitution is express in its discussion of criminal punishment? This is how Judge Chutkan contorted herself to try and find some way to keep these cases marching along. Because she's like, oh, you know what? If you look for Nixon v. Fitzgerald in that civil case, we had a whole analogy as to the nature of his protections from civil liability. Okay, that's dealing with civil liability. What the heck does that have to do with whether he can be criminally prosecuted? Excuse me. But the court explained that notwithstanding their absolute civil immunity, prosecutors and judges are subject to the criminal prosecutions as are other citizens. Okay. Damon Blackfire, Ford wasn't smart, just a massive neocon who was appointed to torpedo the U.S. in Nam. No. Oh, you're saying he wasn't stupid? I don't know. I remember hearing how stupid he was growing up. Although, to be fair with you, when I'm searching the cobwebs in my brain about Gerald Ford and going like literally way back into my youth, anything I would have heard back then would have been from my parents in the late 1970s. And back then they were Democrats. So, but even as Democrats, they liked Reagan, didn't like Carter. They hated Carter. But, yep, it's true. Mea culpa. Mea culpa. In sum, the district courts concluded that former presidents do not possess absolute federal criminal immunity for any acts committed while in office. Court similarly rejected respondents' claim that his acquittal in impeachment proceedings afforded protection under double jeopardy principles. I don't like the double jeopardy principles at all. Or the impeachment judgment clause against his criminal prosecution after leaving office. Reasons for granting the petition. A cornerstone of our constitutional order is that no person is above the law. The force of that principle is at its zenith, whereas here a grand jury has accused a former president of committing federal crimes to subvert the peaceful transfer of power to his lawfully elected successor. Nothing could be more vital to our democracy. Nothing could be. Oh, I need the violins. That's what I need here. I need violin. All right, we're gonna please pretend that this is violin. that this is violin music. A cornerstone of our constitutional order is that no person is above the law. The force of that principle is at its zenith, whereas here a grand jury has accused a former president of committing federal crimes. To subvert the peaceful transfer of power to his lawfully elected successor. Nothing could be more vital to our democracy than that a president who abuses the electoral system to remain in office is held accountable for criminal conduct. Yet respondent has asserted that the Constitution accords him absolute immunity from prosecution. The Constitution's text, structure, history lend no support to that novel claim. No one, even if it says it expressly there, it's not there in the text, which we threw down the garbage disposal. This court has accorded civil immunity for president's actions within the outer perimeter of his official responsibilities. Civil. So civil protections for a president are greater than criminal protections. Oh, okay. That makes a lot of sense. Yeah, a president is kept safe from civil. He has civil immunities, but no immunity from criminal prosecution. We're not allowed to touch his pocketbook, obviously, because the Constitution stops us from doing that. But to punish him criminally? Oh, for sure. Nothing in the Constitution says anything about that. Nothing in the text. I'm looking and I'm looking here. I'm looking there in the text. I know it. If only it said convicted somewhere, like convicted of something. If only it said it somewhere, but it doesn't. The Constitution that we threw in the garbage is completely silent on it. And the executive branch has long held the view that a sitting president cannot be indicted while in office. But those principles cannot be extended to provide the absolute shield from criminal liability that respondent, a former president, asserts. Neither the separation of powers nor respondent's acquittal in impeachment proceedings lifts him above the reach of federal criminal law. Like other citizens, he's accountable for criminal conduct. It was beautiful. This is random, but if the following is a cult, does that make its members Joe-ish? Joe-ish, not Joe. Joe-ish. It would be if I was the leader of the cult, of this cult, which I am definitely not the leader. I'm a follower just like you. I do think that you should join today. I think it's very important that you join this cult, which is very unculty. And that riches will be bestowed upon you, not from me or anyone associated, but karma, good karma, will certainly rain down upon you as you striving toward greater community, stronger unity, and your own personal growth. So clearly, blessings will flow unto you. Not for me. And not that I'm the leader of the cult, because I'm not. And it's a very non-culty cult. One of the ways it's a very unculty cult is that there's no leader. So for all those reasons, now maybe there are people, you know, I don't see how Joe-ish would really work. Schindler's List violins, not Mazel Tov music. I had that listed as clownish backgrounds. What's this one? That's what I wanted. Hold on. I got one more. I gotta see. I put these in a while ago. See, that's what you... I always like the bagpipes. I like the bagpipes. When do we start smashing plates? Oh, you got a whole Greek thing from it? I see that. I'm Jewish. Are you? Well, I'm very flattered. Thank you. You can all be Jewish. All right. Where was I? I was peeking in on my was peeking in on my whatchamacallit. I'm not doing that. Okay, that would be funny, but no, I'm not going to do that. Okay. Back to our story. The district court presiding over this case rejected the respondent's constitutional arguments and has scheduled trial for March 4, 2024. Respondent's notice of appeal, however, suspends trial proceedings. This is why he doesn't want to get suspended a second time. This is why he's trying to go straight to the Supreme Court. And respondent has moved for a stay of all proceedings in the district court while his appeal is pending. It is of particular public importance that respondent's claims of immunity be resolved as expeditiously as possible. And if respondent is not immune, they receive a fair and speedy trial on these charges. Why? Why is that of public importance? Like, how is this relevant to anything? We keep saying he's no different from anyone else. So why is it of public importance? The public, respondent, and the government are entitled to nothing less. The respondent, we're going to force you to go run to trial whether you like it or not for your own good. It's for your own good. It's for your own good, Donald. Yet, if this case proceeds through the ordinary and even a highly expedited appellate process, it is unclear whether this court will be able to hear and resolve the threshold immunity issues during its current term. You might get pushed to next September. You might get pushed all the way back to then. What's going to happen? What's going to happen? For that reason, the government seeks a writ of certiorari. Certiorari. Everyone calls it certiorari, but it's actually certiorari. Before judgment, to afford this court an opportunity to grant review now and ensure that it can timely resolve the important immunity question presented here. The United States recognizes that this is an extraordinary request. This is an extraordinary case. It's a very important case. The court should grant certiorari and set a briefing schedule that permit this case to be argued and resolved as promptly as possible. This case satisfies the standards for certiorari before judgment. So now we have to explain, because you don't, unlike trial courts, appellate court, you don't have an automatic right to get in before the Supreme Court. This is something that a lot of I think the overwhelming majority of Americans don't understand about the way the Supreme Court operates. It's not like you can just get in there. You need to basically sell the Supreme Court that this is a case that they should be listening to. And that's being granted certiorari, or granted, people will just say granted cert, is when they're talking, they'll usually just refer to it as cert, for CERT. So this case satisfies the standards for cert before judgment. The court has jurisdiction to review cases in the Court of Appeals by writ of certiorari before or after rendition of judgment or decree. See, you have the power to do it. You know you have the power to do it. You can do it. It's not like there's no law stopping you. You can jump in there. An application for writ of certiorari to review a case before judgment has been rendered in the Court of Appeals may be made at any time before judgment, according to Statute 28 U.S.C. 2101E. A writ of certiorari before judgment is appropriate when the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination in this court. And I will grant him this. I will grant Jack Smith this. If there's a case that's going to jump the line, this feels like it probably should be it. This feels like it should be it. If there's a case that's going through the normal processes that should jump the line, this really does feel like it should be. I can't deny that. I mean, this is a case that everyone's focusing on. This case involves a paradigmatic issue of imperative public importance, the amenability to criminal prosecution of a former president of the United States for conduct undertaken during his presidency. It requires no extended discussions to confirm that this case involving charges that respondents sought to thwart the peaceful transfer of power through violations of federal criminal law. What? Oh, sorry. It requires no extended discussion to confirm that this case, which is involving charges that respondents sought to thwart the peaceful transfer of power through violations of federal criminal law, is the apex of public importance. So, yeah, it's such a long sentence that I kind of lost track of where he was going. It requires no extended discussion to confirm this case is the apex of public importance. That's true. It doesn't. The charges implicate a central tenet of our democracy. We don't have a democracy, so no, I don't think that's true. But I can say it's a central tenet of our republic. And the charges allege that the respondent conspired to transgress the law in manifold ways by intentionally using fraudulent means to obstruct, blah, 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 the 5 ways, which are 6, and seeking to deprive millions of voters of electoral choice for president. No, the point is, that's what your charges are. He was actually seeking to ensure that their voices were heard. Sadly, he failed. The district court set this case for a trial on March 4, 2024 to ensure fulfillment of the public's interest in seeing this case resolved in timely manner. You see, they keep saying in timely manner, in timely manner. What does timely mean in this context? Other than like, we have to get this in before the election. We have to get this in before the election. We must get to this right now. We have to know. The public interest in a broad sense, as well as constitutional guarantee of a speedy trial, commands prompt disposition of criminal charges. Strunk the United States. Vindicating the public interest in this case requires immediate resolution of the immunity question to permit the trial to occur in an appropriate timetable, or to blow it up in its face. To basically take this case and the Georgia case and all these stupid and the Florida case, basically put them in a big pile, and then you get that big thick stack of TNT, and you put it underneath these cases and around these cases and on top of those cases, and then you start rolling out the wire, stand at a safe distance away, and then stand over that big box with that T shape and just that's essentially we need that TNT now. We need it now. All right, careful what you wish for. You might not be saying Merry Christmas. Yes, the rest of the country would. If appellate review of the decision below were to proceed through the ordinary process in the Court of Appeals, the PACE review may not result in a final decision for many months. We might have to wait for the appellate court for a whole bunch of months, and then it's going to come to you guys, and it's going to get put on hold then. Even if the decision arrives sooner, timing such decision might prevent this court from hearing the side of this case this term. Precedent supports expeditious action. He's desperate to get in there. Oh my God, get me in there, please. Get me before the Supreme Court. I would say this. What would be amazing, is if he were to somehow lose this case 9-0. And then I think we need to start looking in the annals of history whether anyone has ever gone 0 for 18 in front of the Supreme Court. That's what I'm starting to wonder. Has anyone ever gone 0 for 18 in front of the Supreme Court? It's possible. It's possible. Doesn't seem easy. Seems like a tough charge. Seems like a tough thing to do, to basically bring 2 cases for the Supreme Court and never convince a single justice that you know what the hell you're talking about. Because I think this decision from Judge Chutkan is so backward, and he's running to the Supreme Court to basically give her decision the seal of approval. And I don't see how they do it. It sounds so, everything she wrote there sounds so stupid. I can't even imagine how it's going to happen. I'll be so shocked. If this decision from her survives the Supreme Court. I will be astonished. I'm not kidding you. I'll be really astonished. Precedent supports expeditious action. When the government sought certiorari before judgment in U.S. v. Nixon, a case presenting similarly consequential issues of presidential privilege, a court granted petition and resolved the constitutional question expeditiously so the trial could begin as scheduled. So over here, he's trying to explain why it is that we shouldn't just get cert, but you should be fast-tracking us. Move us to the front of the line. Bring us in, grant us certiorari, cert, give us cert, and then jump us to the front of the line. Why? Because the United States v. Nixon, which is a case that had similarly consequential issues of presidential privilege. The court granted petition in that case. There, what happened was the district court overseeing one of the Watergate cases had scheduled a trial to begin on September 9th. On May 24th, the special prosecutor sought cert before judgment following the district court's denial of former President Nixon's motion to quash a subpoena seeking Oval Office recordings. The court granted cert a week later and set the case for argument on July 8th. So over there, when we had the whole Watergate tape thing, and this whole issue, does the president have to follow and take subpoenas or not? So, yeah, you granted cert and moved things along pretty quickly. The decision issued 16 days later and trial began in the fall of 1974. This case warrants similar action. As in Nixon, public importance of the issues presented and the need for their prompt resolution merit the court's intervention now without awaiting completion of appellate proceedings. And as in Nixon, that is true even though the district court correctly denied respondents' presidential immunity and related double jeopardy claims. So even though we won at the district court level, we still need you to move things along quickly over here. While no precedent supports respondents' claim as a former president to criminal immunity, which sucks for me, Jack Smith. Oh, sorry, that doesn't suck for me. He's saying that there's no precedent that helps him out. The government acknowledges that this court has not addressed a comparable claim. Oh, sorry, I misread that in my brain. So he's like, he doesn't have, while really what Jack Smith is saying, really nobody knows what the law is here. Because this is completely novel. This has never come up before, and no one knows. So the president's got no precedent. I've got no precedent. No one really knows what the law is. And this is a quintessential example of an important question of federal law that has not been, but should be settled by this court. And that I agree with too. Nobody can decide this other than the Supreme Court. The Supreme Court punts on this. My God, what a humiliation. In recent years, this court has often granted cert before judgment in cases of imperative public importance that warranted immediate termination by this court. And let's give a whole list of cases that this court has granted cert in the past. Okay. This court should order expedited briefing so that it can consider and decide this case promptly. Government is filing this petition for writ of certiorari before judgment, not only because of the public significance of the issues, but to ensure that the case may be briefed, argued, and decided during the ordinary decisional time for the cases argued this term. As noted above, the district court has scheduled trial for March 4, 2024, and respondent has appealed. Which, by the way, it seems even crazy. It seems crazy that he should have to go to court on March 4th, even if this was granted cert. First and foremost, if you're Trump's attorneys, you need to be working on your response to this now. This is not something you wait to see if what the court says. They should be working through the night with tons of lawyers working on their opposition to this now. This is not something you play around with. Given the uncertain timing of appellate proceedings, but let's play this out. Let's assume that they expedite everything and they manage to come in before the court, given expedited scheduling, and tell Trump, hey, you got to get your papers in here within the next week, 10 days. And they're going to grant a decision. And they grant a decision on this in January. You're going to tell him he has to go to trial 2 months later? That sounds crazy. 6 weeks later, he's got to be in trial. It makes no sense. It makes no sense. There's so many facts. It just sounds crazy. The whole timing of this just seems like so ridiculously unfair. Given the uncertainty timing of appellate proceedings in the ordinary courts, including potential requests for rehearing en banc, certiorari before judgment is appropriate, which this is another thing, by the way, because what could happen ultimately is it can go before the circuit court, and then they could ask for a rehearing en banc, meaning when it comes before, what does en banc mean? So when it comes before the circuit courts, you have a panel of judges, 3 judges from the circuit court. The circuit court has 20 judges, 25 judges. So they basically select 3 of them to handle it. And I think they're supposed to be randomly chosen. and they write their decision. But often, when it's an important case, they'll ask for a rehearing from the circuit court en banc, meaning the entire circuit court should hear it all over again and reach a joint decision by the entire circuit. So you have like and if it's a case like this, where it's such an important case, it's very possible that will happen. So if it goes to the circuit court and we wait for a decision there, and then it goes for a rehearing, and then en banc over there, and then it goes up to the Supreme Court, it could take them like a year and a half until they reach a decision on this thing. And that's what Jack Smith doesn't want to see happen. So that's what he's terrified of, and that's why he's trying to push this thing along as quickly as possible. I know Trump is fighting this. He's fighting the timing on this. And I get it. And his lawyers, that's the proper legal strategy. It is the proper legal strategy for his attorneys to be fighting this. And to be looking to kick this can as far down the road as possible. I'm simply saying, I think politically, I think that this lingering over Trump has been a windfall to his polling numbers. And this hanging over his head. So maybe that's why he wants to keep it there. But if he were to lose at trial, and get convicted, I don't see how he loses the 2024 election. I don't see how it's possible. I think people will be outraged. Given the uncertain timing of appellate proceedings, in the ordinary course, including potential requests for rehearing en banc certiorari before judgment is appropriate now to allow the court to provide the prompt and definitive resolution that the issues presented here require. Because of the discretionary nature of this court's consideration of this petition, meaning because we recognize that you have complete discretion as to what you do with this petition, and because we don't want to have any more delays, we're also filing a motion to expedite proceedings in the D.C. Circuit, which currently has jurisdiction over the appeal. So please don't take offense by the fact that we're coming to you and saying, hey, grant us cert and move us along. And at the same time, you'd be like, why are you coming to us when you're looking to move things along the circuit court? So what he's basically saying, and this is a proper thing as an attorney for Jack Smith to be doing, is he's like, look, I don't know. The future is very uncertain. I don't know what you're going to decide. You might grant me cert. You might and expedite. You might not grant me cert and not expedite. I don't know what's going to happen here. You might deny me cert. So you're going to see, and it's going to come to your attention that while I'm making this application, I'm also going to the circuit court, which this case is currently pending, and I'm going to ask them to expedite stuff there. But I'm really doing that as like option B in case you deny me cert here now and don't let me come in with this petition right here and now. So that's what he's explaining. As that motion explains, government is seeking prompt resolution on the appeal in time to allow this court to hear and decide the case of this term in the event the court opts not to grant the petition before judgment. Because it's possible that the Supreme Court will be like, it's premature. Let's see what the circuit court does. By the way, on this issue, I think it's important for me to inform you, there's a fairly decent chance that the court's going to do this. There's a fairly decent, because one of the things that this court has displayed is a certain reluctance to display much of a backbone. And I know you say, what about the Dobbs decision overturning Roe? That required some backbone. I think that was sort of like their pet project. I think that they feel like it's possible that they'll sit there and they'll be like, you know what? If the circuit court gets it right, and they end up finding in Trump's favor, we don't really need to weigh in on this. We don't need to and we can sit back and basically, if they come close enough to being right, we don't need to face the political backlash that we will invariably face if we deny cert when they try bringing it from the circuit court to us. Because once again, whoever wins or loses at the circuit court level, whoever loses is going to appeal to the Supreme Court. And if Jack Smith loses and the Supreme Court denies cert at that point, that's not quite the same political backlash that they'll face than if he win. Then if they grab this case away from the circuit court and say we're blowing this case up right here and now. That requires a certain level of backbone that has rarely been displayed by this court. A case in point as to where they failed to display it is in Texas versus Pennsylvania in December of 2020, when they said we're not touching this case, which was a complete, to me, cowardly move that violated the Constitution, that the Supreme Court itself violated the Constitution in failing to take that case, which I felt that by law, by constitutional law, they were certainly obligated to take it. So, and I think that they were motivated by cowardice, Chief Justice Roberts' cowardice specifically. I think that he told Amy Coney Barrett and Kavanaugh, "You're not signing off on this thing," and then didn't get in, and it was never granted cert. So that being the case, if there's a lack of backbone, I think they might say, you know what, we don't have to grant cert, and if we don't grant cert, we can see what the circuit court decides and then decide what we're going to do with granting cert at that point. So if they deny cert, which is a possibility, that doesn't mean that they agree with Chutkan or disagree. It really would just be like, we can avoid political backlash. And that would not be a novel approach for this bench, for this court. If the court grants review, the government respectfully requests that establish a schedule for briefing and argument that would allow this case to be resolved as promptly as possible. You've kind of said this already. He's getting a little repetitive now. Alternatively, if the court opts not to grant review immediately, the government respectfully suggests that it consider postponing action on the petition pending further proceedings of the Court of Appeals so the court can grant certiorari immediately upon the issuance of a decision by that court. So if you don't want to give it to us now, don't reject us outright. At least keep us our place online, because this is coming to you one day. One day this case is coming to you. So if you don't want to grant cert before the circuit court makes a decision, at least just put this on the side. Don't just like flat out reject it. And if the court elects not to review this case at this time, it may wish to note that the Court of Appeals should proceed with sufficient dispatch to permit the court to hear his case promptly during his currently scheduled argument sessions for this term. So that he's basically saying, if you don't want to grant cert now and you want the circuit court to weigh in, can you at least push them along to act quickly? Can you at least say, hey, circuit court, move that thing along? So he's basically trying to get from the Supreme Court whatever he feels like, whatever would help expedite this, and basically laying out a smorgasbord. Smorgasbord? Is it smorgasbord or smorgasbord? Jews call it smorgasbord, but I have a feeling that that's a Jewish bastardization of the word smorgasbord. I am very curious. I'm very curious whether you call it, especially if you're Swedish, because I think the Swedes are the inventors of the word. Is it smorgasbord or smorgasbord? Like, because every wedding, every Jewish wedding starts with the schmorg, and that's what we call it. You know, did you get there in time for the schmorg? So my question is, but it's spelled definitely smorg. There's no H in there. I'm positive that there's no H in there. So that's why my question to you is that a Jewish bastardization, or is that something that non-Jews say also? Do they say schmorg as well? If I actually said, did you get there for the smorg? My friends would look at me like I was out of my mind. They'd be like, what? What did you call it? What'd you call it? What? All Jules Sergeant says, SCOTUS granted cert. Trump has till 12/20/23 to reply. So there you go. There you go. I appreciate. When did that drop? When did that shoe drop? Clearly after NFL started playing tonight. $5 hours ago. Well, no more naps for me. All right. Well, there you go. Is SCOTUS like family court petitioner has the advantage? No. 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 They said he cannot run if he's found guilty. I don't know where they come up with that. Who's they? Who's they? Why would he not be able to run if he's found guilty? How would that be? Ironic if he's called in front of his SCOTUS. Yeah, it is pretty funny. It is pretty funny. Especially because his SCOTUS has kicked him in the pants so many times. Like I said, I don't think they like him. I don't think that they like him. But I do think that what I do think is that those three moderates, I think that they do like the establishment. I think they're hardcore neocons, and I think that even that what they believe in is not having our country turn into a banana republic, which is what it will assuredly become if they don't invoke the rule that I suggested. Given Smith's prior Supreme 8-0 SmackDown 9-0, is Smith taking a huge chance here? Isn't he overstepping going directly to the Supremes? Seems corrupt. It's an unusual move. It is a very unusual move. It's very, very unusual, especially because he's the winner. Normally, you don't expect the winner to say, hey, I want to fight this all the way up to the Supreme Court. But it is a realistic move. I don't think it's a foolish move on his part. I don't think it's foolish because if it's given his objective, which is he wants to get this thing done as quickly as possible, I don't think it's a foolish move. It's an unusual move, but I don't think it's foolish. And he's not someone who I'm quick to laud praise upon his legal skills, but I think this was probably the right call because he recognized realistically how this is likely to play out. So, and he spells out how it is that they're able to jump in even before the circuit court issues its opinion. And sure enough, the court bought it, so that worked. Lily says, they said he cannot run. I don't what is Smith's legal justification to rush? He says he just wants to avoid delay. The elephant in the room is the election. Yeah, which he claims is not anything that's really relevant to anything. We can gag him because who cares if he's running? That's not really relevant. No man is above the law. But we're going to move this along much faster than we would anyone else because we have to get it done before the election. It's so corrupt. It is so grossly corrupt that it's disturbing. It's really disturbing. I wanted to share with you. Where are you? Where are you? Is this it? Is this it? I don't know if I have enough time to go through. In fact, I know I don't have. I know this. I don't have enough time to go through the gag order because that's going to take me a long time. But there's something shorter that I wanted to pull up, and that was. Is this it? No. Yesterday, when I was streaming the X Space, and Laura Loomer was on there. Laura Loomer was on there, and I was addressing my thoughts about Laura Loomer, where I basically said I think that she has an I didn't refer to what I basically was implying was an unfortunate mouth to brain ratio. So I wanted to share with you. I could have sworn I put it aside here, and I'm having trouble finding it. I'm not going to get you. I'm getting a little frustrated that I can't find it. Comer. Son of a gun. I want to share with you her attack on someone related to Trump. Related to Trump because you know that she's a pretty frothing in the mouth, frothing at the mouth Trump fan. This might take me a minute to find now, though, because I thought I put it aside and I don't see it. Here it is. Oh gosh, she tweets so much. I told you, crazy mouth to brain ratio. All right. Let me open this up and let you see what I'm looking at, so at least it's less boring for y'all. I'm looking through her timeline here. This is Laura Loomer. There's one story in particular that I wanted to get to. Look how much she tweets. This is all like in the last like couple of hours. Oh my God. Just scrolling down. And I saw this like this morning. I'm like, how far down am I going to have to go to find this stupid thing of hers? Oh my God. Please stop. Even this is what I want to show you. Nikki Haley admits on video that she's a fan of leftist tool Taylor Swift. So she likes Taylor Swift. Who cares? It's like, what a weird way to it. It's such a weird way to attack Nikki Haley. She's trying to say, oh, how can you like someone who's a leftist? You know what? A lot of people like Taylor Swift music. Is it my thing? No. But I can understand that a lot of people like her music. So they're going to say they like Taylor Swift. But because she's so neatly aligned with the left, does that mean you have to pretend that she doesn't like her music? Or that means that her music tastes have to change now because I mean, it's such a ridiculous way to attack Nikki Haley. This is what I mean by when I say way too big, way too much mouth to brain ratio. It's just like, let me find something to attack on, even if it doesn't really make much sense. She doesn't like Jenna Ellis, which I agree with her on her sentiment of not liking Jenna Ellis. I have real issues with Jenna Ellis also, but it's the nature of the way she attacked Jenna Ellis. This is it. Now we're getting it. Now this is the thing. Okay. Look at this. Look at this attack that she makes on Jenna Ellis. She basically says Jenna Ellis engaged in forgery and bigamy and should be in jail for fraud and all sorts of like stuff. Okay. Exclusive. This is her exclusive on Loomered. And I'm just like, this is just, am I the only one who thinks that this is just schlock? Forensic document expert says Jenna Ellis may have forged secret first husband's signature on annulment documents, casting doubt on her credibility as Fani Willis's witness. Okay, share the scoop with us, Laura. Even the font looks like it's like this is like the font that she chooses is manifesto font. I'm convinced that this has to be manifesto font, right? I mean, look at this. Who the heck reads something like this? This is totally manifesto font. That it's like this tiny print crammed together. This is totally manifesto font. That's what I thought. I thought a pre-cert briefing. What did I see here? I thought it was a pre-cert briefing, not cert, which is an argument as to whether or not they should grant certs, not an actual briefing of like what's supposed to. God damn it. Petitioner's motion to expedite consideration of the petition for a writ of certiorari before judgment is granted. And respondent is directed to file response to the petitioner on or before 4 p.m. So whether or not we should consider it before the circuit court issues some sort of judgment, that's what he has to respond to. Not whether or not he wins, but just any argument. If you have a problem with us considering it, before it goes to circuit court. You have opposition, arguments as to why we should not jump in front of circuit court. Bring that forward to us, to our attention by December 20th. And if you don't, then we may grant cert. And if we grant cert, that means you'll have to brief at that point your opposition to their petition. That's how I understand this also. I appreciate you pointing out. That's a very important distinction you made there. It's a procedural distinction. It's a very important one, which means that they may still say, we're not going to hear this at all. We might not grant cert. But they specifically are asking for expedited cert. If you don't want cert, if you don't want us to come in here now and jump in front of the circuit court, then let us know your position and why, and what your legal basis is for it. Yeah, I agree with you on that. Reed. This is totally manifesto font. That's what I'm telling you. I hear in the chat that Nick announced the stream is going to start at least 30 minutes late, maybe more. I'm trying to say I've added time. I appreciate that. Thank you. What about Tucker's new channel? I haven't looked at his new channel yet. Are there good things? Are there good things? Have you heard good things? Let's say I have time to look at that. Maybe we'll take a moment to look at that. Okay. Rumor is Thomas O'Leary may retire. Imagine Trump pointing up to 5 Supreme Court justices. That's wild. Yeah, but he sucked on 2 out of 3. So I don't know how much I love that. And I'll tell you this much. Whoever he gets to replace Thomas is not going to be Thomas. It's not. Also, maybe a way to rein in the far left. I don't know how it's reining in the far left because you're replacing 2 conservative justices. I got to tell you something. That's one of the reasons this next election is so important. Can you imagine if we get 2 more KBJs? What a disaster this world will become. All of a sudden, Roe v. Wade will be wakened from the dead. They'll resurrect that aborted baby. All right, so this is what I was focusing here on Laura Loomer. I apologize for getting sidetracked here momentarily. Jenna Ellis, her self-proclaimed legal career. Look at, by the way. So this is in her best. Tell Alex to reach out to me. I'll talk to Alex. Tell him to reach out to me. I'll get back to him. I was actually chastised by a brother-in-law of mine yesterday that he texted me a couple of times and I didn't get back to him. He's like, "You're so busy, so busy. Oh, Joe, you're so busy. I can't even. You can't even like look at my WhatsApp." He made me feel so guilty. He made me feel like such a jerk. All right. Jenna Ellis, her self-proclaimed legal career, her image as some type of devout Christian woman, and even her odd personal life can be summarized with one simple phrase: fake it till you make it. Ellis sells herself to the American public as a kind-hearted Christian woman. And of course, let's not forget how she pretended to be a Trump supporter in the aftermath of the stolen 2020 presidential election in an effort to gain favor with the same Trump supporters she continuously bashed in 2016 when Donald Trump first ran for president. Regardless of the many layers of concealer that Jenna uses to cover up her lack of qualifications, that's a dig at her for using concealer, and her mean-spirited core, her opportunistic and disloyal true nature continues to shine through. So who is Jenna Ellis and why does she even matter? In short, Jenna Ellis somehow managed to trick her way from being a Trump hater, failed attorney, I don't know that she's a failed attorney, to unfortunately representing President Trump when it mattered the most to our country. And she did so without having any actual meaningful qualifications while misrepresenting her resume. How do you know that? I don't know how you know that. That's an interesting charge. And now, As President Trump is in the middle of running for re-election for the 2024 presidential election, Jenna Ellis is once again misrepresenting herself in an effort to interfere the election by flipping on Donald Trump and agreeing to be a witness against him in Georgia. After months of scamming donations from kind-hearted MAGA supporters to the tune of $216,000 following her indictment, which I agree with Laura on this, that was terrible what she did, which she said she intended to fight, Ellis took the money and made a plea deal with Fani Willis in which she agreed to testify against Trump. And then she pled guilty in a charge that Fani Willis brought against her and read a statement aloud in court while crying. And there's a little link to it. I believe and I value election integrity. If I knew then what I know now, I would decline to represent Donald Trump in these post-election challenges. Yeah, the alligator, the crocodile tears there. Oh, look at that. She even says that crocodile tears. Yeah, there were a lot of crocodile tears. For those failures, Your Honor, I take responsibility before the Colorado bar who censured me. The deal endorses a sentence of 5 years probation, $5,000 restitution, and 100 hours community service in exchange for having no contact with the media or co-defendants and cooperating with testifying at other trials in the 19-person RICO case, potentially including Trump. Steve Sato, Trump attorney, called the plea deal what it is, a farce. For the fourth time, Fani Willis and prosecution have dismissed the RICO charge in return for a plea into probation, which is why they all were charged. Sorry about that. What this shows is the so-called RICO case, nothing more than a bargaining chip for Willis. Yeah, I agree with him on that. I think Sato is a good attorney from what I've seen. Moreover, this plea was to completely separate charge, not a part of the original indictment, which doesn't even mention President Trump. There's a little thing. And now she starts getting repetitive, Laura. $216,000, confession. It's just like $216,000, confession. Remember when I mentioned too much mouth for the brain? Okay. Deception and fraud to interfere in 2024 election have been outlined, sourced above. However, in an exclusive investigation, what's her scoop here? Records and annulment documents portray Ellis as an individual obsessed with money, lies, and religious deception. Ellis married Irish national Shane Butler on December 24th, 2014, but her official marriage ceremony took place on Valentine's Day, 2015. Ooh, scandalous. And the notary stamp of her annulment paperwork shows during a May 6, 2015, which means her marriage was shorter than 6 months long. Rather than getting divorced, Ellis pursued an annulment. The difference between annulment and divorce is that annulment states that the marriage never should have taken place, mostly due to the fault of the spouse. In a lot of Christian communities, annulments are accepted while divorce is not. Okay. Ellis's annulment paperwork portrays Butler as a freeloader and Miss Ellis as an immigration scam victim. Ellis has not been public about her marriage to Butler. And even more strange is that Butler supposedly signed his name on the annulment, which accuses him of these serious allegations before an individual named Ryan Snell. Not to be confused with what's that awful Snell who super chatted me earlier, who notarized the annulment document, according to the official notary stamp of the document. However, handwriting experts believe Miss Ellis forged both Mr. Butler and Mr. Snell's signatures, meaning, if true, Miss Ellis committed fraud and perjury. Worse, Ellis was remarried following the annulment. If Ellis forged the annulment would be invalid, meaning Ellis committed bigamy. This is like... So I have one individual who's claims to be an expert who says that there was a forgery, which means now she's committed fraud and bigamy, and it's like, has he complained about it? Did Butler complain about it? Court records pertaining to her annulment proceedings show Ellis also lied about the actual date of her marriage. On her official annulment record, Ellis said she married Butler on December 24th. But she told the court in the annulment testimony she was married on December 23rd. Bum, bum, ba-da-da-da-da-da. Really? Like this? Could we get like more like ticky-tacky than this? Did Ellis lie about her marriage date because she knew getting married on Christmas Eve would be a bad look to her Christians she constantly asked for donations from? What? Is that true? Getting married Christmas Eve is a bad look? Says who? What are you talking about? What does that mean? I don't understand what Laura's talking about here. Either way, lying about your marriage date under oath is a crime, and lying under oath leads most lawyers to disbarment. Like, so she's off by a day on what day she got married, and therefore she should be disbarred, and all her credibility is shot, and there's forgery going on here because one person said so, and she should be disbarred, and she's engaging in fraud, and she's engaging in bigamy. And here's my scoop. What's her scoop? Her scoop is that some handwriting expert that I don't know if Laura hired or not basically said that the signature looks the same. It looks like it was done by the same person. So here she pulls up the dates. In the same proceedings, Ellis told the court that she did not believe Catholics and Christians were the same religion. This is an interesting development considering Miss Ellis seems to have a close relationship with March for Life. Catholic organizations play a crucial role in March for Life. Okay, I don't know what I don't understand. What this is like the craziest scandal. There's no there. This is like Fannie Willis's indictment. I don't know what are you talking about? What here is so terrible? And I don't like Jenna Ellis. I'm not a fan of Jenna Ellis. But it's like, oh my gosh, scandal, exclusive scandal. Handwriting expert says it's the same. I'm like, what? This is like National Enquirer is sitting here laughing at her ridiculous journalistic standards. I mean, how clickbaity can you possibly be? Look, I'm not going to kid you. When I look at this, I'm like, okay, I see how the swoop in the S there looks kind of the same. I get that. Okay. I can understand why someone would say that these signatures look similar. The date looks similar, but the date could be filled in by anyone. Anyone can fill in the dates. According to annulment documents, within 2 months of marriage, Ellis made a claim. Petitioner Jenna Ellis discovered that co-petitioner Butler cannot make an income through music and songwriting that would be substantially similar to his income in Ireland. Remember, Butler did not move to the United States until Butler and Ellis were married, meaning Ellis gave Butler less than 2 months to find a job in the United States. She's such a terrible human being. Butler's failure to make income was Ellis's primary reason for the annulment. Proving something like failed income is a key to annulment to be approved. Mr. Butler allegedly signed the annulment document portraying him as a deadbeat husband. But did he actually sign this document, which degrades his performance as a husband and tacitly accuses him of immigration and marriage fraud? It tacitly accuses him? Does it? Does it really? Does it really? Why would someone sign a document accusing themselves of those things? Maybe he wanted out of the marriage. Maybe he thought that she was like a machshefa and he wanted to get as far away from her as possible, as quickly as possible. So he's like, okay, fine. Yeah, I suck as a songwriter and I need an annulment because of that. That could be one reason. If you were married to Jenna Ellis and you spent a couple months living with her, when the luster starts wearing off, maybe you'd be looking for annulment also. Is that such a hard thing to conceive of? Because to me, it's pretty logical. You probably would sign anything. Did he complain ever about this annulment, saying, "Hey, I never signed that"? There's no claim of that. Plot twist: is Christian Jenna Ellis a bigamist? When I said she had too much mouth for her brain size, I had not even seen this yet. I saw this today, and I'm just like, wow. This is just you have to be kidding me. Is Christian Jenna Ellis a bigamist? It's Rachmanis. I'm looking at this and I'm like, okay. So now she's not really annulled. She's really still married. And now that makes her, because one person says that it's her signature on everything. So therefore it's fraud and it's bigamy and in 2019, Ellis married David Rives, an author, documentary maker, Christian radio presenter, and speaker who runs David Rives Ministries. Technically speaking, Rives was Ellis's second husband, but I have confirmed that upon marrying her in June of 2019, Rives was not aware that Ellis had previously been married to Shane Butler. Bum, bum, bum. Well, I guess Laura's confirmed it. Like her short-lived marriage to Butler, which lasted less than 6 months, Ellis' marriage to Rives lasted only 2 months, and the couple divorced after 2 months of a marriage. Sources have confirmed to me was mentally exhausting and emotionally draining for Rives. So that I can believe. According to one report, Ellis and Rives' relationship journey started with the engagement in April 2019, followed by their wedding in June. Unfortunately, marriage hit rocky waters, leading separation in August, a mere 2 months post-nuptials. Because Ellis pretends to be such a devout Christian woman, her sketchy annulment and hidden facts about her first marriage to an Irish national, who she may have fraudulently separated from via forged documents, prompted a private investigation into who this woman really is. Who is Jenna Ellis? What does this woman who is working with Fulton County's District Attorney Fannie Willis to sabotage President Trump have to hide? Apparently a lot, and enough to discredit Ellis entirely. I don't know. I don't know if this discredits her entirely. I don't really understand that. Frankly, Laura Loomer's claims that her annulment is a forged document, I don't even know if that's going to make it before a judge, and that's if the judge is even impartial. If I was sitting as a judge in this case, and I got into a point where Jenna Ellis now just testified against Trump at a trial, and now I'm sitting here and they want to be cross-examining and they want to impeach her credibility. They want to say, I want to impeach her credibility. I want to bring forward annulment documents and have a handwriting expert come in and say that she forged it. I'd be like, this is way too much of I think there's a good chance. I'd be like, this is really a bit of a stretch. If it's proven in court that she forged it, then yeah, of course. But one person claiming that it's a forgery and therefore she's not trustworthy? Really? I don't think I'd let that in. I don't think that would get in. I don't think any of this would get in. Any of it. Because it's too, because anyone could, you think that it's impossible to find one jackass out there who would say, oh, it looks like a forgery to me, so now you can't trust any testimony this person said? That sounds ridiculous. Think about, just take out the names Jenna Ellis, Donald Trump, or whatever. Just think like logically for a second. Just sort of put your thinking caps on, okay? Someone gets up there and testifies and gives very damning testimony against Mr. X. Mr. X, we'll call him Chuck Schumer, okay? Gives very damning testimony against Chuck Schumer. Now that he gave damning testimony, or against Menendez, okay? So now they gave testimony, terrible testimony against Menendez. Okay. Now Menendez's lawyers say, we want to impeach this person. I want to impeach him because he signed off on this deal that no one ever complained about. And I don't think they signed it. And I have an expert who says that it looks like the same person signed both. So it probably was him who signed both. And therefore, based on the testimony of this handwriting expert, we can now deduce that it must be that this amazing witness, it now has no credibility because some expert says that they think that that is speculating that they're the ones who committed a fraud. There's zero chance this gets in. It's so stupid. By that argument, anyone could be indicted. You just find any handwriting expert, and anyone's credibility can be indicted, because you just get any handwriting expert, pull up some document that they had, and the handwriting expert will be like, oh, it looks like forgery to me. So don't trust anything they just said, which was really terrible for my client, because we found some schmuck out there who we paid $20,000 to, who says that this document that this person signed, which has nothing to do with this case, was fraudulent. No judge is allowing that in. That's ridiculous. It's stupid. Oh. So no, it's not enough to discredit Ellis entirely. Nothing that you said here is probably even admissible in court. I'm just being real with you. And again, I don't like Ellis, and I would love it if we actually had something that would make her testimony easily impeachable. Say she's full of crap. But this ain't it. This ain't it. I'll know when I see it. I'll know that if it has a chance of making it. When I see it, I ain't seeing it now. This is not what I'm seeing here. Wendy Carlson is a certified question document examiner who has studied handwriting document examination, apprenticed under leading court qualified forensic document experts at the USA, been qualified as an expert in the state, local. It doesn't matter. It's one person's opinion about one document. Carlson was proved appointed by federal and state court judges to render opinions. Okay, she's a real super duper expert. During this investigation, in which the findings were exclusively related to me, Carlson's examination of paperwork said, based on my scientific examination of documents submitted while using an application of accepted forensic document examination tools, based on the line quality, the rhythm, slant, height ratios, placer, to me, it looks like the same person signed both. Okay. Who says Jenna Ellis is the one who signed both? Maybe Butler signed both. You don't even know that. You don't even know that. Maybe Butler was wanted out of there so badly that he forged it. How do you know it wasn't him? Oh, you don't know that. Even if we... There's a testimony here is that one person signed both Jenna Lynn Ellis and Shane Edward Butler's signatures. Okay. That's nice. And how do you know that it was Jenna Ellis who signed both? You don't. Now, would it be logical to conclude that? Do I think that if there was a forgery here, do I think it probably was Jenna? Yeah, I mean, she's a petitioner. You tend to come to that conclusion, but you don't know that. Furthermore, a simple electronic examination of Stephanie Stout's signature on the attorney's signature line reveals that this signature appears to be a static copy of an image and not handwritten ink, and no pixelation of the static image. Pixelation? I don't know. If Ellis did forge both her signatures in notary, which evidence is overwhelmingly pointing that she did, the question is why? Could it be because Mr. Butler was actually not a deadbeat as Ellis portrayed, or it could be that he wasn't in the same state as her and it was just simpler and he said, please just get it signed and submitted. Or could it be, see, this is so stupidly speculative that it's basically like, I feel like I'm like on Inside Edition. Could be that Ellis was moving on to select another man to victimize and torment with her lies. This is the brain. This is the brain who's sitting here consulting with like the leading minds of the right. I can't. Sorry, it bothers me. It bothers me. Turns out Butler had a growing reputation, exceptional songwriter, which led to invitations to collaborate with an elite list of artists. So he really was really great. Oh my God, this is like so. This is so stupid. This is just who listens to this crap? And then she starts repeating it all over again. Here we go through the forgery and ramifications and bigamy and fraud, and it's the same in the forensic handwriting, and she writes the same thing all over again. And here we go with the bigamy again, and it's just like the same thing over and over and over. I get frustrated when people are expressing opinions that I would like to be true. It feels so clickbaity. It feels so it feels scammy. It does. It feels scammy. And I'm not saying that Laura Loomer is a scam. I'm not saying. I want to be 100% clear on this. And I'm not saying this. I'm not jokingly saying it. There's no hidden meaning in anything I'm saying. I don't know that she's engaging in a scam. If it is, I can't see what the angle of the scam is other than getting attention. I'm simply saying it just feels scammy. It just feels like what the, like it feels like you just want me to click here and click there and click there, and you're making pennies on every time I click something. It's just, that's because anytime I read something like this I'll see an article which says like, her mother's, she never knew that the man she loved was actually out to scam her of every penny that she had. But she thought she had the perfect life, but really the love of her life was scamming her every penny. And you start clicking more, and she's like, they met in college. But it was that's so I feel like I'm reading with this. Only it's in manifesto font. Who would use manifesto font? Why do people use manifesto font? And don't tell me that there's a better name for this. Please. I don't want any of you to claim there's a better term for this font than manifesto font. Yeah, I amuse myself. Okay. All right. All right. So Tucker, so you want me to cover the Tucker thing? Let me see what I got going on here. Evening, Joe. Hey, Kavo, how you doing? And as far as reigning in the left with SCOTUS appointees, yeah, Amy Coney Barrett has notoriously sided corporations and not the Constitution. So 5 more of those, and we're still screwed. Yeah. Yeah, it's very scary. Very, very scary. Hamilton Berger, member for 1 month. Member for 1 month. In fairness, that is some New York Times level journalism Laura Loomer is demonstrating, and just as unbiased. Well, welcome. Welcome to the following. The following is not a cult type of cult at all. There's been a lot of Laura Loomer-esque type reportings about the cult, saying that about the following. Saying it's such a culty cult. It's like one of the cultiest cults you've ever seen. They have meetings in the forest with people wearing like robes and hoods and lies. None of it's true. None of it's true. Very unculty cult. We were on a break. I don't know what this is. I know that's Ross, but what are you getting at? Oh, you're talking about the annulment? This is like small if true. Who cares about any of this? Yeah, but that's what I'm saying. It's like exclusive. It's an exclusive. She's bigamy fraud. She's no credibility. It's like, this is so stupid. Source, are there... I don't even know. That's not even an English word. I busted my lip when I fell down the stairs yesterday. Are you making me laugh on purpose, Joe? If I pull my stitches, I'm sending you the ER bill. I'm glad you're enjoying. Mama Ford, thank you for the support and love. I appreciate it very, very, very much. A bit of a stretch can make her a bigamist. Yeah, a bit of a stretch. This is like Plastic Man. Plastic Man is like wincing in pain from this. He's like, you're breaking Plastic Man, Laura. You're breaking Plastic Man. Oh, let's go. If you have a master's in handwriting analysis, ask Joe's handlers where exit stage left is. We are all Joeish. Join us. Be like us. All right. I don't know what you want me to tell you. What happened there? I was trying to like... Yeah. I wanted to see about Tucker's channel here. All right, let me see what I got. Unlock all new shows from Tucker and his team, exclusive interviews and investigations, trust and news commentaries, a direct line to Tucker and his team. $6 a month. Wow. Oh, so it's $9 a month, but $6 if I pay a lump sum up front of like $72. Still, that's countless hours of exclusive content from Tucker and his team. It's time to build an alternative to legacy media, and if you help us do it, it's time they stop hiding the truth media. We'll expose them together. Where do I get like must-see videos? The Tucker Carlson encounter with John Daly, uncensored debate over aid to Israel, Dana White interview, most powerful interview around the world. Man, I miss smoking. I really do. Kids, don't start smoking. It's bad for you. But I miss it. Tucker in Hungary, a speech that made the media mad. Return to Hungary, the Budapest speech. Watch all. All right. Well, look, I'll tell you this. I like Tucker. I don't always agree with Tucker. I'm not sure if I agree with his position. I'm a little confused about his position on the war. I don't think he has a position on the war, which I'm okay with that. Other than that, we should be looking out for American interests, which I agree with. And he has a natural cynicism of the government. I agree with that too. He's right for that too. We should. What do you want me to tell you about it? Am I going to end up signing up? Chances seem very high that I'm going to end up signing up for this. If I join now. If I join now, I'm just wondering, like, if I share his content, am I like violating anything? Let me see what he's got here. TC shorts Tucker in Argentina. Stay in your lane. He's got a whole thing going on here. Uncensored. Imprisoned by Zelensky. Uncensored. More money for Ukraine. Apocalypse never.
If there's a single tableau that kind of sums up the moment we're living in, it's a group of half-demented 80-year-olds sitting around yelling about things they don't really understand. And no, that's not Thanksgiving dinner with the...
I like that he's doing this. I like it. I mean, it's ironic that a bit of a stretch. Yeah. I'm not going to start smoking. Just saying I miss it. Anyway, I think I'm going to wrap up here. I think it's time for me to get a move on. It's 12:25. It's time for me to call it a night. Don't worry, I'll be back tomorrow. You'll see me tomorrow. Fans says Jenna Ellis become a full-blown woke Democrat. Democrats are only path forward. Oh, I don't like Jenna Ellis. I'm just saying I have a I don't like when like people are expressing an opinion that I lean toward, but like in a crazy way, because that just makes me feel as if people are going to hear me express a similar opinion that's rooted in completely separate bases, and just think, oh, you're with, it's like, I don't like Q, the whole Q, thing for people who want to join Alcoholics Anonymous. Like I'm just like, you're a bunch of lunatics, and I don't like associating with you. And just because you're expressing an opinion that like comes to conclusions that align with mine, I think it's healthy to call that out and say, yeah, okay, I understand that they land where I land, but they still kind of suck a little bit. Only diggers have a sense of humor. Not just the diggers. Everyone, look, diggers have a good sense of humor. That's true. The diggers are a reference to those of you who my people who hang out in my locals chat. So if you were wondering what the diggers reference is, if you're new to the show, and if you are new to the show, I appreciate if you could like and subscribe. I want to just show one last thing to you. This is the weirdest thing to me in the world. Every time I come in here, and close with this. Every time I come in here to Rumble, so I'll the only way you can check your likes is if you hit like, and every time I hit that button, I'm always making it 67. I got 438 people watching here on Rumble, 438 of you, and I'm showing 67 likes. When I unlike and re-like this now, it'll probably be something like in like 20 seconds, it'll probably be like somewhere around between 85 and 92. Now that I call attention to it. That's the way it goes. But it's always 67 when I first check it. It doesn't matter how many people are watching. If there could be 240 people watching on Rumble or 430, it's 67. Makes me wonder if it's actually working. Let's see the number. Oh, it's working slow. 77. All right. Here's a 10 spot to celebrate my getting a blue check mark on X. My account has been set free again. Finally getting new followers for the first time since 2016. Oh, I'm happy for you. I was explaining this on Locals today. And this is something I want to share with all of you. I think Twitter is going to explode in a positive way. I think Twitter is going to explode. I really think that the addition of video to the Twitter spaces is going to give Twitter an angle, which now is called X, is going to give X an angle that no other social medium can compete with. The ability to cull together different voices, different leading voices into one space on a moment's notice gives X a massive edge of this is live, this is now, this is what's happening, this is the news, this is what's happening. And the biggest drawback to that of Twitter Spaces over the last year, since it really started taking off, has been that it's just audio, and people need video. They need to see the person who's talking to them. And when it's just audio, you don't feel as connected to what you're engaging in. When they add a video component to that, so that all of a sudden you can jump in and look at that. There's Alex Jones hanging out with Vivek Ramaswamy and Matt Gaetz, and that can happen like that. So, and the reason this is so significant is imagine if this was around, if this was instituted in October of 2020 and it was being run by Elon Musk back then. On election night, when things start shutting down, think of all the Twitter spaces that would be opening up with tens of thousands, hundreds of thousands, millions of people all like assembling around different panels of, what's happening here, what's going on. It would become not just a town square, but the town meeting hall. But I foresee that X is going to become something that is worth 2 to 3 times, quickly become worth 2 to 3 times the $54 billion that Elon paid for it. And I don't care about these advertisers being chased off by Media Matters, because at the end of the day, what the ability to just have people spontaneously come together as events are unfolding in real time, because more people will start coming to the platform, more people will start looking toward X as a place to get their news. So you might not be part of the whole X thing. I get it. A lot of people don't like it, and I didn't join up on X until after COVID came. I'm simply saying, I think that this is something that is likely to significantly change social media. Significantly. And all it takes is the video element of Spaces. Because Spaces already is just created the idea to have conversation, just boom, instantly, to have conversation with different sides of the aisle, that you don't have to be in your echo chamber, that all of a sudden you can just pluck out someone, and I could be having a conversation with like 50 people, 100 people, have that balloon up to 200, 300 people, and the next thing I know, there's a congressman sitting there talking to me. That's like an amazing thing. That's an amazing thing that never existed before. That all of a sudden, so imagine if it's election night there, that it's like, holy hell, that Matt Gaetz making the rounds, Chip Roy making the rounds, Ted Cruz making the rounds. That's what we'll see. And I think this is so significant because it'll make it much harder for them to hide their lack of integrity. When things are suppressed and quieted out, whatever, when you have tens of millions of people who are all like screaming at outrage, it motivates action. It motivates people recognizing something has to happen here. And that's why I think that Elon obtaining X and turning it into something that is basically must-see social media, which is what I think this is going to happen. I'm telling you right now, it's going to become huge. It's really going to become huge. I believe it very firmly. Oh, Alex meant to be on it. It's better than Trump and Vivek. Trump and Vivek. Oh, and Trump and Vivek? Oh, that's right. Well, happened before X goes bankrupt. How can I get Elon to let me back? X not going bankrupt. X not going bankrupt. I think that he likes having this social significance. I think Elon will, even if he has to fund it, he doesn't care. I don't think he cares. I think he appreciates the social significance of what X can be in the world. And that's why it's not, I'm not saying it's going to be making money. I'm simply saying it's not going to go bankrupt. The other thing I was saying is that I think this could have a domino effect where other companies, if they see, if this does start having the success of eyeballs and leeching people away from YouTube, because they actually can engage in free speech, that they can just, I'm sitting here on a podcast, it's me talking to you. Do you know what a cumbersome thing it is for me to like try and figure out how I would get Vivek to talk to me? I gotta schedule that like days, weeks in advance. Even if I know him, if I wanted to get Nick Ricada on here, who's a friend of mine, uncivil, it's such a cumbersome thing that this platform is not equipped for. Whereas it's like literally I can have like a surprise guest of Ted Cruz on a Twitter space, and there's video where I'm like having a video conversation with the guy. That's crazy. And that never existed before. It's an amazing idea. And I'm telling you right now, I'm a lot of confidence is going to be really massive. And yes, that would change spaces. Can you imagine? All of a sudden, that would have changed the whole election right there. It's very 1776. Family fathers debating things in a bar, not on CNN. Yeah, it really is. It really is. It's an amazing time to be alive. It's an amazing time to be alive. Anyway, on Twitter, if you're on X or Twitter, I'm at the following pro there until I get the Good Lawgic name back. It'll say like my name is Good Lawgic, but like the Twitter handle is at the following pro, as in the following program. So, which is what this show is called. So, I'm wrapping up here. I think it's the end of our show. I think we're reaching the end. It's time for me to start like landing my plane and telling you all sorts of things as far as where you should be going and what you should be doing with your life and your world and things of that nature. So, I will be back here, God willing, tomorrow evening. Very much looking forward to hanging with you guys at that point. I don't see Nick Ricada having set up a stream here anywhere, so too bad, so sad for you, my brother. I love you, but it's not going to happen. It's not happening. All right. Let me make sure I didn't miss anything. Good there. Good here. I'm good everywhere. I'm good everywhere. All right. I will see you all tomorrow. I'm going to see if I can try to put up some sort of locals tomorrow also. Goodlogic.locals.com. It's goodlogic.locals.com. Right now, I got to go check out and see how my football played out. So be happy. Eat some bugs. And as always, Godspeed.